Dr. Kristine Bowman serves as Associate Dean for Academic and Student Affairs in the College of Education at Michigan State University, where she is jointly appointed as a Professor of Law and Professor of Education Policy.
That's the First Amendment. That's it. So when we are thinking about these words, there is so much case law that is built on this very small amount of words. And as you can see, there's not a whole lot of clarity in this. So we have a lot of cases, but also a lot of other laws and policies that have come to shape what free speech means over the years. Individual speech is presumptively protected by the First Amendment. So this is sort of the default position. The idea is that individual speech is protected unless there's some reason it should not be. Constitutional rights only come into play when we're talking about government action. So public institutions, the state of Michigan, Michigan State University, City of East Lansing School District. So those are a few examples of government institutions. Most higher education institutions in the US will basically play by the rules of the First Amendment, even though they're not obligated to, because it's important to them because of the mission of higher education that they do so. Harmful speech is protected because the government cannot regulate based on viewpoint. And so when we see all the types of speech that students have engaged in over time, we want to think about the range of viewpoints that are available. Governments regulate the content of speech, but not the viewpoint of speech. So the content might be, we cannot talk about a particular topic. We cannot talk about a general concept with ideas on either side of it. So speech harms are protected because of that restriction on viewpoint discrimination. It's very important under the law to have multiple viewpoints be able to be heard. So counter speech, who are we thinking should be doing the counter speaking? Where does that burden fall? And so my question for us is, okay, if this is part of what the law requires, because we cannot restrict that bad speech up front, then how can we share the burden of engaging in that counter speech? Some of the most amazing examples of counter speech relate to student protest. We often hear the term hate speech, and I want to clarify for us that hate speech is not a legal concept in the US. It's a social concept. It's something that you and I could talk about, and we both will have an idea in our head of what hate speech is, what would constitute hate speech, but no one can go to court and say this person engaged in hate speech and that's not okay. Not in the US. So in the US, the law really focuses on this distinction between speech and acts. And so I want to offer this definition of how I think of open expression on campus. Equitable access to inclusive spaces of learning and knowledge creation. Another question, and this again is something that we all can think of, and part of the things that we can do is to think more about how we can support robust open expression. So first, what does robust open expression mean to you? And then how can we support that? Different societies think about free speech rights differently. So I want to present this to say that there is this continuum of meanings of free speech. And it's not only individuals who think about free speech in various ways, it's entire countries and cultures who think about free speech in various ways. And law has evolved to think about free speech and to, again, remember, go back to that phrase from the First Amendment, to think about what that phrase means in all of these different contexts.